Hello friends, today I am talking about environment impact assessment notification that was released by MOEF-CC. Initially it was MOEF, now it is MOEF-CC. On 14th of September 2006, Ministry of Environment and Forest. So this notification is released under Environmental Protection Act and the rules, so which are necessary for restriction and prohibition on use of certain projects and activities or expansion or modernization of existing projects or activities based on their potential impact which is being undertaken in any part of our country, any part of India. And even it is mentioned as part of national environmental policy that it is our commitment to protect the resources of our country. It is the prior requirements under environmental clearance that central government or the state or union territory, so there should be an Environment Impact Assessment Authority, SEIAA in case of states, and it should be duly constituted by central government in consultation with state government or union territory administration concerned. So central government, as part of it, Ministry of Environment and Forests and Climate Change, now it is renamed from MOEF to MOEF-CC, in the matters falling under category A of this schedule. And the state level Environment Impact Assessment Authority, SEIAA, for matters falling under category B as per the said schedule. So before any construction work or preparation of land by the project management, except for securing the land is started on the project or activity. There are certain projects which require prior environmental clearance. There are three conditions. First one, all new projects or activities which are listed in schedule to this notification, EIA notification 2006. I am talking about it. Number two condition, expansion and modernization of existing projects or activities which are listed in the schedule of this notification. And number three condition, any change in product mix in an existing manufacturing and included in schedule beyond this specified range in this notification. Now I will talk about state level Environment Impact Assessment Authority. The member secretary shall be a serving officer of the concerned state government or union territory administration familiar with environmental laws. The other two members shall be either a professional or expert fulfilling the eligibility criteria. One of the specified member who is an expert in the environmental impact assessment process shall be chairman of state level Environmental Impact Assessment Authority, SEIAA. The state government or union territory administration, they have to forward the names to the central government, and central government shall constitute SEIAA, State Level Environment Impact Assessment Authority. The non-official member and the chairman shall have fixed term of 3 years. All decisions of SEIAA authority shall be taken in a meeting and shall ordinarily be unanimous. All projects and activities are broadly categorized in two categories. Remember, category A and category B, based on spatial extent of potential impacts and potential impacts on human health and natural and man-made resources. So based on space the impacts cover, and based on impacts they cause on natural and man-made resources. So all projects or activities included as category A in the schedule, which is provided at last of this notification, including expansion and modernization of existing projects or activities and change in product mix, they shall require prior environmental clearance from the central government. So in the Ministry of Environment and Forests. So it was MOEF at that time. So on the recommendations of an expert appraisal committee which works in central, which works in MOEF or MOFCC now, to be consulted by the central government for the purpose of this notification. All projects or activities included as category B in this schedule will require prior environmental clearance from the State or Union Territory Environment Impact Assessment Authority, SEIAA. The SEIAA, State Level Environment Impact Assessment Authority, shall base its decision on the recommendations of State or Union Territory Level Expert Appraisal Committee, SEAC in State, EAC in Central, which is constituted by the state governments, SEAC. Screening, scoping and appraisal committees. The same expert appraisal committee, EAC, at the central government, and SEAC, which is working at state or union territory level, shall screen, scope and apprise the projects or activities in category A or category B. So as per their functions, as per their work assigned to them. EAC and SEAC shall meet at least once in every month. So per month meetings are conducted. SEAC at the state or union territory level shall be constituted by the central government in consultation with concerned state government or the union territory administration. So governments or the union territory administrations, they constitute SEAC for more than one state or union territory for reasons of administrative concern and convenience, administrative convenience, and also of the cost reduction. The EAC and SEAC shall be reconstituted after every 3 years. The authorized members of the expert appraisal committee and state level expert appraisal committee concerned may inspect any site connected with the project or activity in respect of which the prior environmental clearance is sought. They have this right for the purpose of screening, scoping or appraisal with prior notice of at least 7 days to the applicant. So who shall provide necessary facilities for the inspection to these committees. The EAC and SEACs, they shall function on the principle of collective responsibility. Now, as part of application for prior environmental clearance, An application seeking prior environmental clearance in all cases shall be made in prescribed Form 1. Remember, Form 1, its format is given at the end of this notification, and Form 1A, if applicable, it is part of Appendix 2. After the identification of prospective site or sites for the project or activities to which the application relates, before any commencing any construction activity or preparation of land at the site by the applicant, so it is necessary. So there are different stages in prior environmental clearance. I will talk about it now. The environmental clearance process for new projects will comprise of a maximum of 4 stages. These are common as per this notification, all of which may not apply to particular cases as set forth here I am talking or as per the notification. These 4 stages in sequential order are: number 1, stage 1, screening, only for category B projects and activities it is carried out. Stage 2 is scoping. Stage 3 is public consultation. Stage 4 is appraisal. I will talk about the stage 1, screening. So in case of category B projects or activities, this stage will necessary scrutiny is carried out of the application who are seeking prior environmental clearance. So application should be made in Form 1 towards the concerned SCAC for determining whether or not the project or activity requires further environmental studies for preparation of an EI for its appraisal prior to the grant of environmental clearance, depending upon the nature and location specificity of the project. The project requiring an environment impact assessment report shall be termed as category B1, and the remaining projects shall be termed category B2 and will not require an environment impact assessment report. B2 do not require, B1 require EI report. Stage 2 is scoping. Scoping refers to the process by which expert appraisal committee in the case of category A projects and state level expert appraisal committee in case of category B projects or activities. B1 I will specially call B1, so including applications for expansion and or modernization and or changing product mix of the existing projects or activities. So they determine here in this case the detailed and comprehensive terms of reference, TOR, remember this word, addressing all relevant environmental concerns for the preparation of environment impact assessment report in respect of the project or activity for which prior environmental clearance is sought. The expert appraisal committee, EAC, or state level expert appraisal committee, SEAC, concerned shall determine the terms of reference on the basis of what information furnished in prescribed application Form 1, Form 1A, including terms of reference proposed by the applicant, a site visit by subgroup of experts, appraisal committee or state level expert appraisal committee, central or state, concerned, so only if considered necessary. All projects and activities listed as category B shall not require scoping, remember, and will be apprised on the basis of Form 1 or 1A and the conceptual plan. The terms of reference TOR shall be conveyed to the applicant by EAC or SEAC within 60 days of the receipt of Form 1. So there is condition, there is time frame. So in case of category A, hydroelectric projects, the terms of reference shall be conveyed along with the clearance for pre-construction activities. Remember this line. If the terms of reference are not finalized and conveyed to the applicant within 60 days of the receipt of Form 1, the terms of reference suggested by the applicant shall be deemed as the final terms of reference approved by the EIA studies. See how it is condition. If not, as suggested by applicant. The approved terms of reference shall be displayed on the website of Ministry of Environment and Forest, now it is MOFCC, and the concerned state level Environment Impact Assessment Authority. The applications for prior environmental clearance may be rejected by regulatory authority of the concerned state on the recommendations or by the center in case of category A on the recommendations of EAC or SEAC at this stage. So in case of certain rejections, the decisions together with reasons for the same shall be communicated to the applicant in writing within 60 days of the receipt of the application. So again, this is a condition on EAC, SEAC members. Stage 3 is public consultation, public participation. Public consultation, it refers to the process by which the concerns of the local affected persons and others who have plausible stakes in the environmental impacts of projects or activity are considered, ascertained in a view of taking into account the material concerns in the project or activity design as appropriate. Exception to public consultation is public consultation is not required for certain projects, and these are the modernization of irrigation projects. All projects or activities located within industrial estates or parks approved by concerned authorities and which are not disallowed in such approvals. Expansion of roads and highways which do not involve any further acquisition of land. No need for public consultation. Maintenance, dredging, provided the dredged material shall be deposited within port limits. All building or construction projects or area development projects, public consultation is not required, and all category B2 projects are activities. So all projects or activities concerning national defense and security are involving other considerations, strategies as determined by the central government. So they do not require public consultation. These are the exceptions. Now, what are the components of public consultation? I will tell you here. A public hearing, this is a more common and more famous word, at the site or in its close proximity, district wise, to be carried out in a manner prescribed as per the appendix 4 of this notification, and to get certain concerns of the locally affected people. So obtain the responses in writing from other concerned persons having plausible stakes in the environmental aspects of the project or activity. So the public hearing at or in close proximity to the site or sites, so in all cases shall be conducted by State Pollution Control Board or the Union Territory Pollution Control Board, UTPCC or SPCBs, and forward the proceedings to the regulatory authority concerned within 45 days of a request to the effect from the applicant. If the public agency or authority reports to the regulatory authority concerned that owing to local situation, okay, it is not possible to conduct the public hearing in a manner which will enable the local people, individuals, persons to be freely expressed, it shall report the facts in detail to the concerned regulatory authority, so which may, after due consideration of the report or other reliable information that it may have, decide that the public consultation in the case need not include the public hearing. So it may be decided under certain conditions. So for obtaining responses in writing from other concerned persons having a plausible stake, interest in the environmental aspects of the project or activity, the State Pollution Control Board or Union Territory Pollution Control Board, SPCB or UTPCC, they shall invite the responses from such concerned persons or placing on their website the summary EI report prepared in the format given in appendix 3A as per this notification. The confidential information, yes, of course, it is not displayed, including non-disclosable or legally privileged information involving intellectual property right, source specified in the application, okay, is not placed on the website. The regulatory authority concerned may also use other appropriate media to ensure wide publicity about the project or activity. The regulatory authority shall so make available on a written request from any concerned person the draft EI report for inspection at a notified place during normal office hours till the date of the public hearing. See, all the responses received as part of this public consultation process, they shall be forwarded to the applicant through the quickest available means. So it is the condition on them after completion of the public consultation. The applicant shall address all the material environmental concerns expressed during this process and make appropriate changes in draft EI and environmental management plan. The final EI report so prepared shall be submitted by the applicant to the concerned regulatory authority for appraisal. Now, next stage is number 4. It is called as appraisal. Appraisal means the detailed scrutiny by the expert appraisal committee or state expert appraisal committee of the application and other documents like final EI report, outcome of the public consultations, so including public hearing, proceedings, so submitted by the applicant to the regulatory authority concerned for grant of environmental clearance. So this appraisal is green signal whether to give or not, shall be made by expert appraisal committee or state level expert appraisal committee concerned in a transparent manner in a proceeding to which the applicant shall be invited for furnishing necessary clarifications in person or through an authorized representative. See the condition. So on conclusion of its proceedings, the expert appraisal committee or state expert appraisal committee concerned, they shall make categorical recommendations to the regulatory authority concerned either for grant of prior environmental clearance or stipulated terms and conditions or rejection of the application for prior environmental clearance. So together with the reasons for the same, so they may accept or they may reject the application for EC. The appraisal of all projects or activities which are not required to undergo public consultation, as I already told you about exceptions, or submit an environment impact assessment report, so shall be carried out on the basis of prescribed application form 1 and form 1A as applicable, and any other relevant valid information available, and the site visit where the same is considered necessary by EAC or state level environment expert appraisal committee concerned. If they feel they can go there. The appraisal of an application shall be completed by the EAC or SAC of the concerned state within 60 days. Again, there is time limit of the receipt of the final environmental impact assessment report and other documents in receipt of form 1 and form 1A. So environmental clearance for expansion or modernization or change of product mix in existing projects is related with all applications seeking prior environmental clearance for expansion with increase in production capacity beyond the capacity for which prior environmental clearance has been granted under this notification, or with increase in either lease area or production capacity in case of mining projects, or for modernization of the existing unit with increase in the total production capacity beyond the threshold limit prescribed as per this schedule. So they through change in process and or technology which involves change in product mix, they shall be made in form 1 and they shall be considered by the concerned grant or rejection of prior environmental clearance. Under this point, I will tell you that regulatory authority shall consider the recommendations of EAC or SEAC concerned and conveys decision to the applicant within 45 days of the receipt of the recommendations of the EAC or SEAC. concerned or related. So in other words, within 105 days of the receipt of the final impact assessment report, EI report, so within 105 days, the regulatory authority shall normally accept the recommendations of EAC or SEAC. In case where it disagrees with the recommendations of the EAC or SEAC concerned, the regulatory authority shall request for reconsideration by the EAC or SEAC within 45 days of the receipt of the recommendations which are made by EAC or SEAC. So while stating the reasons for the disagreement, so an intimation of this decision shall be simultaneously conveyed to the applicant, as this is the condition as mentioned in this notification. So in the event that decision of the regulatory authority is not communicated to the applicant within a specified period, the applicant may proceed as if the environmental clearance sought for has been granted or denied by the regulatory authority in terms of the final recommendations of EAC or SEAC of the concerned states. On expiry of the period specified for decision by the regulatory authority, the decision of the regulatory authority and the final recommendations of the EAC or SEAC concerned shall be the public documents, so it is open for all. The clearance from other regulatory bodies or authorities shall not be required prior to receipt of applications for environmental clearance of projects or activities or screening, scoping, appraisal or decision by the regulatory authority concerned, unless any of these is sequentially dependent on such clearance, either due to a requirement of law or for necessary technical reasons. Another important point is misinformation, wrong information, deliberate concealment, fake information and submission of the false or misleading information or data which is material to screening or scoping on the application shall make the application liable for rejection and cancellation of the prior environmental clearance granted. So on that basis, rejection of an application or cancellation of a prior environmental clearance already granted on such ground shall be decided by whom? The regulatory authority. So after giving personal hearing to the applicant and following the principles of natural justice, now we'll talk about validity of environmental clearance. So once it is given, is not permanent, is not continuous. Okay, the validity of environmental clearance is, it means the period from which a prior environmental clearance is granted by the regulatory authority. Okay, the prior environmental clearance granted for a project or for activity shall be valid for a period of 10 years in case of river valley projects, project life as estimated by expert appraisal committee or state level expert appraisal committee subject to maximum of 30 years for mining projects, 30 years, and 5 years in case of all other projects and activities. So in case of area development projects and townships, the validity period shall be limited, so only to such activities as may be the responsibility of the applicant as a developer. Now, what is the next after environmental clearance? Post environmental clearance, the things. It is the monitoring. So in respect of category A project, it shall be mandatory for the project proponents to make public the environment clearance granted for their project along with environmental conditions and safeguards at their cost by prominently advertising it at least in 2 local newspapers of the district or state where the project is located, and in addition this shall also be displayed on the project proponent's website permanently. In respect of category B projects, the irrespective of the clearance, so by MOEF or now MOEFCC or by SEIAA, the project proponent shall prominently advertise in the newspapers indicating that the project has been accorded environmental clearance and the details of the MOEF website where it is displayed. So this is required condition. The Ministry of Environment and Forests, now it is MOEFCC, and the state union territory level environmental impact assessment authorities, SEIAs or union territory levels. So they shall also place the environmental clearance in the public domain on governmental portal. The copies of environmental clearance shall be submitted by the project proponents to the heads of local bodies, panchayats and municipal bodies, in addition to the relevant offices of the government, who in turn has to display the same for 30 days from the date of receipt. So it shall be mandatory for the project management to submit a half-yearly compliance report in respect of stipulated prior environmental clearance, terms and conditions in hard and soft copies to the regulatory authority concerned on 1st of June and 1st of December each calendar year. So all such compliance, so the report submitted by the project management shall be public documents made available to all. The latest such compliance report shall also be displayed on the website of the concerned regulatory authority. Now about the transferability of the environmental clearance. A prior environmental clearance granted for a specific project or activity to the applicant, so may be transferred during its validity to another legal person entitled to undertake the project or activity on application by the transferor, or by transferee with a written no objection by the transferor to and by the regulatory authority concerned on the same terms and conditions under which the prior environmental clearance was initially granted. Now I will tell you under which different categories or the areas, industries, activities they require environmental clearance. Under mining, extraction of natural resources and power generation, so mining of minerals, slurry pipelines like coal and lignite and other ores passing through the national parks, sanctuaries, coral reefs, ecologically sensitive areas. Offshore and onshore oil and gas exploration, development and production. River valley projects, thermal power plants, nuclear power projects and processing of nuclear fuels, primary processing in case of coal washeries, mineral beneficiaries, metallurgical industries, so mainly of ferrous and non-ferrous ores, cement plants, petroleum refining, coke oven plants, asbestos milling and asbestos based products, chloralkali industries, soda ash industries, leather, so skin, hide, so processing industries, chemical fertilizers and pesticide industries and pesticide specific intermediates, so formulation of petrochemical complexes, man-made fibers manufacturing, synthetic or organic chemicals industries, distilleries, integrated paint industries, pulp and paper industry excluding the sugar industry. Now, which are the service sectors? Oil and gas transportation, pipeline, so crude and refinery, petrochemical products, so passing through national parks, sanctuaries, coral reefs and ecologically sensitive areas including LNG terminal. Now about isolated storage and handling of hazardous chemicals, the physical infrastructure including environmental services of the airports, all ship breaking yards including breaking units, industrial estate or parks or where complexes areas, export processing zones, special economic zones, biotic parks, common hazardous waste treatment, storage and disposal facilities, again the aerial ropeways, common effluent treatment plants, CETPs we call it, common municipal solid waste management facility, building and construction projects. So they also require the environmental clearance, and especially under building and construction, area development projects and townships are included. So as part of general condition, so any project or activity which is specified as part of category B, so it will be treated as category A if it is that activity is located in whole or in part within 10 kilometers from the boundary of protected areas notified under Wildlife Protection Act of 1972, or critically located in in or within 10 kilometers, critically polluted areas as identified by Central Pollution Control Board from time to time, or eco-sensitive areas as notified under Section 3 of Environment Protection Act of 1986. For example, Mahabaleshwar, Pachgani, Mathiran, Pachmadi, Dahanu, Doon Valley, and again interstate boundaries and international boundaries. So the category B projects will be considered as category A. So it is over. Thank you very much for being here. Bye bye.